This is breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.
Planting case, which is the Las Vegas Review-Journal, Inc., and 6 of its editorial employees.
May it please the court, Your Honor, David Chesnoff appearing also on behalf of the Review-Journal, along with my partner, Richard Schoenfeld. Good morning, Your Honor.
Joel Taskey, Your Honor, also appearing on behalf of the court. Good morning, Your Honor. Matthew Christian for the Las Vegas Metropolitan Police Department.
Good morning, Your Honor. Pamela Williams is the owner of
Mr. Sheets?
Good morning, Your Honor. Amy Sheets on behalf of Mr. Tellis.
Okay, did you want Mr. Tellis present today, or are you waiving? I'm assuming you're waiving his presence.
We'll waive his presence, Your Honor.
Okay. Okay, you need to file a notice in the civil case as well.
Well, and I indicated to Mr. Hammer this morning, I've been retained to represent him on the criminal matter. I've been authorized to step in on the civil matter as of yet, so he's represented by Mr. Helming in the civil matter. That would currently remain, but I am representing him on the underlying criminal matter, so until I have the authorization on the civil matter, I can't file an NOA.
So Mr. Helmick is continuing to represent him on this case, and he's not present today?
I informed Mr. Helmick that I have not yet been retained on the civil matter, and I informed Mr. Hammer of the same this morning.
Okay. Well, and he's received notice of the hearing. There's going to be a lot of attorneys. I'm assuming you're going to want chairs. Also, how can we make sure that you have...
I'll certainly get one from Ms. Kissinger.
I mean, I don't know how long it's going to be, but I'm assuming everybody doesn't want to stand the whole time.
You want a seat? Good.
All right. So there's 2 matters that are on. The hearing regarding the remand from the Supreme Court regarding the Mr. Chairman's vehicle. I don't know if you want to start there. And then there's the motion for sanctions.
Your Honor, I would suggest a different order. I would suggest that we do the motion for sanctions first for a couple of reasons. It's independent of the merits and the other motions. And if the court were to grant the motion for sanctions, it would moot one of the other motions. It become a motion to dissolve the injunction, because one of the sanctions that was requested was the striking of the pleadings of the state and Metro. So just as a matter of efficiency,
Go ahead.
okay, that'd be great. And before we dive into the merits of all 3 of these motions, Your Honor, I think it's important to place the motions into the context of a larger case. So I'd like to just do that for a couple minutes here at the front end. What's animating the Review-Journal and 6 editorial employees who are the plaintiffs in this case to fight so hard to assert their privilege, the reporter's privilege, is that the position of the defendants in this case threatens to undermine the primary rationale that has led to the development of that privilege. That is a privilege that exists in 42 states by state statute, and a vast majority of federal appellate courts have held that the privilege exists under the federal First Amendment to the United States Constitution as well. And the Nevada Constitution, the Nevada Supreme Court has held that the same protections under the First Amendment apply under the free speech provisions of the Nevada Constitution. And it also led the United States Congress to pass in the 1980s a statute called the Privacy Protection Act. That is a federal statute that, in very clear, short language, says that no person in government at any level can search or seize news gathering materials of a journalist because of the important place in our democracy that the press sits. Now, in this case, we have a situation where that federal statute was violated. It was violated at the moment that these 6 devices were seized by Metro. And the rationale that underlies that statute, the state statutory privileges, and the existence of the privilege in all of the other sources of law is twofold. One is to protect confidential sources. We rely in the United States for much of our information from people who take at sometimes great personal risk to come forward and tell the press about wrongdoing in all corners of society. It may be corporate wrongdoing, it may be individual wrongdoing by people with power, and most of all, they come forward to speak about government wrongdoing at all levels of government. A second rationale is to protect the unpublished information that reporters gather as part of the news gathering process. A reporter goes out, they interview a lot of people, they do independent research, they draft up notes, they take notes of the interviews, they draft their stories. The stories get edited multiple times. All of that work happens before we all read in the press these stories of great public concern. And the privilege protects all of that information too, because as you might imagine, there are many people who would love to know what the press knows before they write about it. Maybe they've gotten wind that a story is going to be written about them, and they want to go and silence other people from talking about it. So the privilege exists to protect this very important process, and it's critical to a well-functioning democracy. It's a crucial aspect of what makes the press free and independent in the United States and sets us apart from the rest of the world in the area of freedom of expression. And Nevadans, in particular, can proudly say that their reporter's privilege is among the very strongest in the nation. Other states have even written about this in other cases.
Hasn't the Nevada Supreme Court repeatedly said it's the reporter that owns the privilege? I mean, that's my concern here, is because the reporter is deceased. He's the victim in this matter. So can the corporate entity, the newspaper, because it sounds like you're asserting it on behalf of him. And we really don't know what's on those devices either, is what I concluded based on the pleadings. No one can tell me what is on those 6 devices.
Let me speak to each of those issues, Your Honor. We have substantial evidence in the record that there's a virtual certainty that there are news gathering materials and probably also identities of sources.
On his personal stuff?
Yes, Your Honor, here's why.
I mean, that's just kind of surprising. I mean, he's a very seasoned, very sophisticated reporter.
Yes. He was also, I think, older than me. I'm 54 years old. I know I still do a lot of stuff on paper. So, I mean, that can play into these things too. But in Mr. Gehrman's case, he had turned in, he did have a computer that was issued by his employer, the Review Journal. It was broken. He took it in for repairs. That was kind of at the front end of COVID.
But that was at the newspaper building,
This is
right?
a long time ago, yes. at the newspaper.
So he didn't bring that to his home? That
Correct.
wasn't one of the devices seized?
That's right.
Did he have the ability to remote into his work computer?
Well, not physically into his computer, but, as we all do, you can remote into some work that exists on a shared drive from
Right.
whatever computer you want
It
to.
appeared as though, based on some of the pleadings, that they had a platform
Yes, they
where
did.
you were supposed to put your stuff and save it.
Yes. Well,
Which makes
supposed
sense.
to put your stuff and save it is not quite right. Okay. In the editorial process, there are things that are shared on the shared drive. But there's no requirement
Google
that
platform?
reporters put everything on this platform, on a Google platform.
Oh, so there's no policy at the RJ
In
in order to keep,
No.
this stuff confidential?
No, there's not a policy at the RJ that I know of. And like in most situations, when people cannot, upload things or whatever, if they need to get something done, they work on their hard
Sure.
drive. Okay, I do this with my own.
And he had been working from home, from what I understand,
Yes.
since the pandemic.
Yes. So we have reason to believe, and we're talking about 4 computers, a hard drive, and a phone. We do know that he used his personal phone for his communications. The review journal does not issue like work-issued phones. It gives a reimbursement to people to pay for the phone, but it doesn't issue its own phone. So I don't think that I think this is kind of a red herring issue because the privilege itself, the privilege materials, very well may be and probably are on these 6 devices because those were the devices he was working on for years before he was murdered.
Why would you work on 6 different devices?
Okay.
Okay.
I have the same question. I don't know. I don't know the answer to that, and I don't know. We'll ever know the answer to that. The question about the standing, you asked about. You
Well,
said,
the reporter owns the privilege. I mean, our Supreme Court has made that pretty clear.
no.
I mean, when
it
Mr.
hasn't.
Greenspan tried to invoke the privilege, the Supreme Court specifically pointed out, no, it's Mr. Pruitt that owns the privilege. Right?
No, actually, in Las Vegas Sun, it was Mr. Greenspan and his brother, which I think was another Greenspan,
Uh-huh.
who was later added into the case, and the paper itself moved. And the court granted the relief to the paper and the 2 publishers.
And that they indicated in that case. I mean, are you suggesting that the reporter does not own the privilege in Nevada? That somebody
Oh, no.
else owns it? Or that it's owned by
It's owned.
more than one person?
More than one person can assert it, right? It's not really an ownership issue. It's who has the right to assert that privilege. And particularly in a case where the reporter is deceased, right? The
It doesn't
employer-
even survive his death. I mean, the attorney-client privilege clearly survives the death of an attorney, but I could not find anything that indicated that it survives the death of the reporter. Do you know of any?
No, Your Honor. We looked, this is just a
I know.
matter of first impression in the United States. This hasn't, it's not every, first of all, we have, again, there is a federal statute prohibiting seizure of this stuff. So the issue wouldn't arise in a case where a reporter was murdered because when people went and seized it. Because most people don't go seize the materials of reporters because there is a federal law prohibiting it. So, the fact that there's not law on this is just because of the way the law is. It doesn't mean that the privilege dies with the reporter. And that wouldn't make policy sense either, right? Which is what underlies the Swidler versus Berlin case that the United States Supreme Court held, that the attorney-client privilege can't possibly die when the client, the privilege holder, dies. That would be terrible. That would undermine the whole purpose of the privilege, which is to have people come forward and talk to their attorney freely, because they might be worried, hey, when I die, all this stuff is going to come out. Same thing with confidential sources talking to a reporter, right? Oh, as soon as the reporter dies, no longer privileged, so I'm not telling them. So,
A confidential source can't assert the privilege.
no.
Only the reporter can.
That's true, but it's the confidential source's reliance on the press to protect its privilege, which it does as an institutional matter regularly in courts all across the United States, firmly protecting their privilege for that very reason, so that the press will still have people coming forward to them and have the knowledge that, hey, when I take this very personal risk to tell the press what's going on here in my police department, I can be assured that I personally am not going to suffer retribution. And so to maintain that, you have to have the privilege live on, and that's what the Supreme Court said in the Swidler case.
As to attorney-client privilege.
Yes, granted, we're talking about a different privilege, but they, both of these privileges, like all privileges, right, are premised on the notion that we want people to speak frankly with people about, otherwise sensitive or confidential matters. Our privilege, the reporter's privilege, is even stronger than the attorney-client privilege, as recognized by our Nevada Supreme Court in Las Vegas Sun and Diaz. We talk about the legislative history, because it's not only supported by the idea of we need to protect confidential communications, but it's supported by an independent public policy rationale that in the United States, the freedom of the press is really important, and this is why our democracy works so well. Also, you know, another point on this about the privilege that the guy with the reporter works for the Review Journal. Okay, this isn't a freelancer or an independent contractor. It's an employee of the Review Journal. All that information that Mr. Garum acquired and gathered painstakingly over his 40 years, which, you know, is cumulative. It's like being a lawyer. I mean, your knowledge is cumulative. Those stories that he started and the sources he cultivated continue on at the Review Journal. They're really the Review Journal stories, the Review
What
Journal
about the stuff
sources.
that's on his devices that was when he was at the Las Vegas Sun? Because he didn't always work at the RJ. He spent a lot of years at the Las Vegas Sun.
That's true. And, you know, this was, I think he changed over in 2011 or 2012. And typically when reporters leave their employment to go to another employer, there's not a dispute. They give over their stuff to the employer they're leaving. And then, you know, can you give up your knowledge, your relationships? Of course, there are certain things that don't go away. But the actual work product stays with the original employee. So this work product that's on his phone, on his computers, belongs to the Review Journal. You know, on the standing point, also, Your Honor, just so it's clear, remember that the privilege that we are asserting is not simply the News Shield statute in Nevada, which, by the way, the title of that statute is news media. The obvious intent of that statute is to protect the materials of the news media. But even aside from that, even if you look beyond that statute, we have a very strong privilege rooted in the First Amendment, and we're equally asserting that in this case. So, you know, the fact that it was Jeff Garriman was the one who created this work product and could have asserted his privilege in life, along with the Review Journal while he was living, and even along with his colleagues who did his investigative reporting on those stories with him and his editors, the privilege doesn't go away once he dies. Toll versus Wilson, Your Honor, is the most recent case on privilege, and that Nevada Supreme Court case says, you know, this is where they applied it to internet stuff. Nevada's News Shield statute should be construed in light of the policy and spirit of the law, and the interpretation made should avoid absurd results. If we were to find that the Review Journal doesn't have standing, or for nobody, I mean, really, there would be the only ones who would have standing. Nobody has standing to assert that privilege. That would be an absurd result in this case. And Mr. Garriman did work, you know, part and parcel with 3 other investigative news reporters, and he had 4 people in the chain above him that he reported to. I mean, it's not like he just writes something and it goes online. It's a collaborative process. And all of those people that are in that chain are here asserting the privilege, along with the newspaper, who is the, you know, the most kind of clear and obvious holder of the privilege. You know, if you look in the legislative history also of the Nevada Shield statute, which is cited kind of at length, it's interesting, in the Diaz and the Las Vegas Sun cases, they cite the 1969 committee minutes, right? If you look at the language of the legislators, they're not thinking about only the reporter. The specific one is the one who gets to assert this privilege. They're talking about...
Well, then they probably should have written the statute differently.
But they
I mean, it says
should.
no reporter, former reporter, editorial employee of any newspaper, periodical, or press association. I mean, it would have to be clearly read into this statute, because it doesn't say it. It says reporter, former reporter, or editorial employee of any newspaper.
Well, you know, this would be a stretch of an interpretation, I guess. It's not clear, just like what you're saying, but Mr. Garriman's a former reporter of the employee, and we're, you know, in his death asserting the privilege on his behalf even.
Well, that's what I'm wondering. That's what I'm getting at. You know, when the attorney dies, the privilege doesn't die, but who can assert it? Can a corporate entity assert it?
Yeah.
I mean, in this case.
Just like
I mean,
in
clearly that's what you're arguing that.
I am arguing
That's my
that.
question.
And that is, you know, Swidler versus Berlin found the same thing. A law firm that employs when an attorney dies, let's say it's not the client, it's the attorney, the law firm is the holder now of the privilege and can still assert it on behalf of the client. So that's an analogous situation. I mean, no matter how you look at this, all the cases that come even close to this very unusual situation we're all sitting in, they all support the rationale that all of the parties who brought this lawsuit have rights to assert here. The Review Journal owns the property by virtue of being the employer-employee relationships, copyright, its trade
Well, you're not
secrets.
contending you own these devices.
No.
Is that correct?
No,
I mean,
correct.
because it seems like to me you're contending you own whatever would be found, information,
News-
data.
Yeah, well, not whatever, because probably there's other stuff.
Right,
surely,
right, you're right, you're right.
Just the scope of stuff that would be news gathering materials
So
related to his work.
information contained
Yes,
in
yes,
these devices.
informational property. And the Review Journal paid him for this work product. It's part and parcel of his, employment. He was a salaried employee. So I don't think it makes sense just as a matter, it doesn't make sense under the legislative history of Nevada state statutes. It doesn't matter under the First Amendment. And by the way, the way this usually comes up, the reporter's privilege, it's not in a case where a search warrant, you have a search warrant situation again because of that federal statute. It's somebody subpoenaing the
Right.
press for information. And you know who appears asserting the privilege in every single case?
The reporter with their lawyer.
The reporter who got subpoenaed, sometimes it's the entity itself who gets subpoenaed. But even if it's not, even if it's just the reporter and the entity appear with the help of counsel, of course. So this is not an unusual thing. We're not like, dancing around. This is just par for the course. It is always the press and the reporter who assert the privilege. And that just, it makes sense as a matter of legislative history for the statute. It doesn't matter to the First Amendment. There's no limitation on it. It's just the reporter. And it just makes sense as a matter of public policy, we wouldn't want the privilege to die. And it's fully supported by a Supreme Court case law in an analogous privilege. So I think the standing argument is extremely weak. I know it gets argued a lot, and you are going to be making new law. But I think it would be bad law to say that there was no standing here, and I think it would be reversible error. Getting a lot of notes. Yeah, and this is, also why, Your Honor, I don't know if you are aware of this. I know you have a lot of paper that was landed on your lap late in the game. But early on in this case, a coalition of 54 news media entities from across the United States filed a leave to file an amicus brief in this case, which is unusual, right, in a district court case. That's very unusual. And they still got 54, the Reporters Committee for Freedom of the Press organized this coalition, and 54 media entities signed on to submit that because of the importance of the law that you are establishing.
Was it denied?
Judge Johnson denied leave to file it simply on the grounds she didn't feel it was appropriate at the district court level.
Are they going to file one in the Nevada Supreme Court?
You bet.
Okay.
And it's going to probably be more than 54. Because actually, I mean, that's I laugh, but that's actually true. I do know that some entities, as a matter of policy, don't file any disputes in district courts, right? Because it's unusual. Your Honor, and just to finish out the standing argument, I just don't know how much of the record you've been able to ingest at this point, but we actually submitted affidavit testimony of multiple people at the Review Journal that establishes, what they do there, how they work with Mr. Bierman, and why it would be that they would have a privilege to assert with respect to materials that were on his device at the time of his death. So the record is fully supportive of the standing of all the parties to assert the privilege, and it's also fully supportive of the fact that the Review Journal owns the property, again, the kind of informational property that is a subset of the materials that is on the 6 devices, and therefore has the authority to move under the return of property statute. Fully
We'll
journal.
get to that, whether that's property as defined under the statute.
I can speak to that now. if you'd
Sure.
like. And I'm kicking myself because I actually had the statute and somehow I left it. But in the main provisions, you know how at the beginning it says, oh, for all these sections.
Right,
sections
clearly
apply.
you're seeking it under subsection E.
Okay. We're seeking
Right?
it under several, actually. I think B, D, and E, if my memory serves.
But you're contending that the search warrant was unlawful?
Yes. I'm contending that the search warrant was unlawful, and that gets, we can get to that now, but that's just part of the motion for sanctions. Before I lose my train of thought, on the definition of property, normally under the return of property statute, you go to the definition that says property is tangible objects and things.
Uh-huh. I mean, because property is defined in our statute.
Correct. However, in the return of property statute, there are several subsections that deal with a privilege, where property is privileged. Now, again, because it's the typical privilege you're talking about, the legislature wrote about property of an attorney, right? And there are property of an attorney sections within that return of property statute, and they're talking about the attorney-client privilege. And in that, it has a special definition that says, for purposes of this, when you're talking about privileged information, property has a different definition. It has a definition of information, right, like we've been talking about, the kind of stuff that we are arguing
You're not
over.
asserting that you own any of these devices, that seems to be clear.
We are not
That they-
asserting any ownership in any of the physical devices.
So it's his estate that basically owns these devices.
One would presume that the estate owns the devices, yes. One last just point on standing, just to kind of wrap it up. We made this argument in our brief. I mean, it's at least arguably law of the case here. The law of the case is established when you have an appellate court decision on an issue. And granted, the Nevada Supreme Court hasn't, expressly held on the standing issue one way or the other. But I think it's worth noting that they did find important, and this important enough situation to grant, injunctive relief. On the additional injunctive relief, the second motion that we're going to be considering today, they have already granted injunctive relief on that, and they even went so far as to say that lasts until further order of this court, meaning the Nevada Supreme Court. So even if you were to not grant that second motion for preliminary injunction, we still have injunctive relief in place until the Nevada Supreme Court says otherwise. And I think that, speaks to the fact that we do definitely have standing, at least the Nevada Supreme Court doesn't see a problem with standing despite the fact that Mr. Garman is deceased. I think I've addressed the issues you had, that we've discussed thus far. So I'll take it back to, if I could take it back, unless you want to stop and talk about anything else, Your Honor, at this point. Okay, let's take it back to where I was kind of putting this all in context. And now I just want to get to the positions of the parties in the case. The position of the defendants in this case is confusing to the criminal defendants. The defendants in this case also include the state and Metro and Mr. Tellis. Their position is just untenable. Their position is we should all be able to search this stuff right now, unfettered, no somebody else looking at it first, and it's untenable because that would just
I'm not
automatically.
sure I've interpreted their position that way, but
Well, they say pursuant to a protective order, meaning just a piece of paper that they sign that says we can't tell anybody what we see. But they have seen it. And the moment that they see it, the privilege is breached. It has been invaded. And And that would be the case no matter what. Let's say this was a case, let's say this was a whole different case. And they wanted to see what was on Mr. Bierman's devices because it was relevant to some other crime, right? And it didn't have to do with, he had no confidential sources within Metro. In this case, we know, and we have submitted evidence saying he had confidential sources within Metro, he had confidential sources within the district attorney's office, he had confidential sources within this courthouse, the judicial system. So this is a particularly sensitive situation where it's particularly inappropriate to have Metro doing the search, which could reveal the confidential sources of their colleagues, or maybe even themselves, who knows, within Metro. Now, those people could be burned, and burned badly, right? Because they are members of Metro.
Well, then they would, whoever did that would have to violate a court order.
They
So you're
would.
assuming people would violate a court order, which,
Yes.
in my opinion, would be outrageous.
It would be outrageous.
I mean, because it
But
seems
we
like
all
you're
know what
arguing that a
happens.
protective order is not enough because people will reveal what they saw anyways.
Look, I'm not accusing Metro of necessarily they're going to go violate this protective order. I couldn't make that assertion. But I equally can't make the assertion that there's no way they're going to violate that protective order. We know that leaks happen all the time. And this is a privilege that has a really important public policy rationale behind it, and also puts at stake personal people, and it's not putting our privileges at risk, it's putting at risk individuals out in this community who have taken, great personal risk to reveal things to Mr. Bierman and the Review Journal in order to bring wrongdoing to light, including within Metro. And so now Metro is going to see that. There's going to just be a natural
Well,
human
homicide
incentive.
detectives, I mean, wouldn't be the entirety of Metro.
That's right.
The only people that would have the need to even look at this would be the two homicide detectives, correct?
Okay, that's right. But what I'm saying is, there's just we have to be real here. There's going to be a natural human instinct. Let's say they see that one of their fellow homicide detectives is a confidential source. Let's say they're also competing with that fellow homicide detective for a promotion. I mean, you can picture the situation. They may have an incentive to go to their superior and say, yes, what I saw during the hours. I'm not the one who told you. If I was violating a protective order, but I just want you to know. These people should not be subject to that kind of stress and potential retribution, and that would kill that person's career, right? And David Roger, who is one of the people that we have offered up to be one of the special masters in this case, he pinpointed that issue. He said, I see a huge First Amendment problem here. These Metro officers who are confidential sources could be badly harmed if Metro detectives were to review this stuff. And so you have the problem with, in this particular case, it's kind of more insidious than the average case. If you had an unfettered review versus a special master kind of review. The people with it could reach the people with the greatest motivation to retaliate against these people, and it would be a huge chilling effect, right? I mean, and more so, it's always a chilling effect when something happens in a case, more so when it's a public case that everybody's watching, right? Now you have people knowing, the Nevada courts are not willing to protect the privilege that the press has, that they tell people all the time, yes, this is off the record, I'm not going to publish your name. All the time that happens. Every day in the newspaper, you will read a story, I would bet, that has that language in it, or doesn't have that
Then why
language.
would Mr. Bierman have that anywhere on a device?
Well, maybe
If you
in
have
his
something that's off
contacts.
the record,
Maybe it's in his contacts. I mean, they have to
but you
keep
think
notes.
his contacts say, this is my confidential source, and this story where I told him I wouldn't say anything?
It may not. Let's say it doesn't. Let's say the Metro detectives just see the name of one Metro detective in there. And they know that person's not the person's friend. That must be a source. I mean, we can't make presumptions about what presumptions they would make, right? And there may well be this information on there. And, you know, we don't even want the two detectives who would be looking at this themselves to see what's on here. Oh, right. I mean, that source could relate to those two people, right? If they're closely involved with them. Or, I mean, it might put them in a difficult, ethical, let's say it's one of the two detectives that they have proposed. Let's say that's the confidential source. What kind of ethical problem does that person now have when they see that they have been outed? And I just, you know, I can't even spin out the hypotheticals there, but you can see that there are serious problems with having this.
Right, but some of those devices may not have any.
They may not. But
It's
why?
just hard for me to believe that every single one of those would have news gathering information, especially when there is this privilege and you're supposed to try hard to keep this stuff confidential. It would be spread out over 6 different devices. I mean, the hard drive, that's, you know, maybe the hard drive is for several devices. I don't know. But it just didn't make a lot of sense to me that there would be news gathering information on all 6 of those things.
I'll just, you know, we're speculating now.
Right, but no one really knows what's on
But
there.
let me just throw this at you. At my house, we have a hard drive to back up all of our various computers on one hard drive. We even have old computers that we used to use in the house that have been backed up on a hard drive. People have different practices of saving information. So I don't think we can sit here and worry about that. We have to make the presumption on the evidence on a record, which is there is virtual certainty that there is news gathering material on there. And what is the harm, right? What is the harm of just having special masters involved reviewing this stuff first, just in case? They may just find out.
I'm not sure there is any harm.
There isn't, which is why this is, it's just, I don't even understand that issue, really. It's unreasonable, and I don't understand why the parties haven't agreed to.
Well, I don't either. I don't understand why the parties haven't been able to reach an agreement.
Your Honor, we proposed a very similar special master protocol before we even filed anything in the Justice Court, which was before we even filed anything in this court. And it was a 10-step, you know, we took painstaking time to let's think about how all this would work. It was a 10-step process, and you know what we got back? It's a 10-step process. We're not going to do that. That happens all the time. This is not an unusual thing that we're asking for when you have privileged materials at issue. Sometimes you need to have a judicial arbiter or a special master. In this case, also another reason why it might be better to have a special master is, remember, he had confidential sources within the courthouse. It's a completely reasonable, kind of like common sense solution. So we thought when we sent the letter on September 23rd saying, hey guys, please don't rush into court about this. Let's just try to work out a protocol together. We literally got radio silence, like not even a response, not even, oh, we like this part, we don't like that part, can you change this? Nothing. Just absolute silence. So we were forced into a position of having to litigate this, and we have been forced into a position of spending hundreds of thousands of dollars litigating this now. That is how much this litigation has cost. And you know, I guess we should probably get to the motion for sanctions, because it really speaks to why that's a huge problem. But I do want to wrap up. There are other sources out there who are at risk. Remember what the crime was all about. Mr. Tellis was the public administrator.
Well, yeah, I'm concerned about that, whether there were people in that specific office. There had to be. I mean, that we know for sure there had to be.
We know there are sources in that. We know, and I think we've put this in the record, they have come to us with concerns. Oh my gosh, they have these devices? What if we are outed in this litigation, right? So we have those people at personal risk. We have the people at Metro at personal risk. We have people in the courthouse at personal risk. We have other people who called the Review Journal when they saw that this happened, and who are working in different corners of Clark County government to say, I'm worried about my confidentiality. And then in the record, we also have another attorney, he's a civil attorney, Brian Berman. Did you see his affidavit?
I did.
And his is really important because it helps you to understand, which isn't necessarily immediately apparent to a person who doesn't do this all the time, why the privilege protects not just confidential sources, but also all the other unpublished information, right?
Oh, sure.
It helps
News
show you
gathering
that, right?
information.
Because he gave information, even though he was an on-the-record source, he gave information and said, this part can be on the record, but this part needs to be off the record. You just need it for background. So we have, that helps demonstrate why that's important. And I think, a ruling permitting what they want would do long-term damage to the news gathering process in Nevada, and not just in Las Vegas, but all across Nevada. And, as I said, we have this strong weapon at our proposal to stop it. We actually have, remember that the privilege is housed in many sources, federal constitution, state statute. Also the federal statute causing the problem in the first place. State statute provides an absolute privilege that has never been, the Supreme Court has never had any case where they said it could be breached. In a civil case,
if they said in
lose it.
Diaz
They did.
that in certain circumstances, and that, I'm going
Maybe.
to tell you, I don't know that I've ever seen a privilege that can't be breached when it has to do with the defendant's Sixth Amendment right to a fair trial.
And there are, and we have put that in the record, California has a very similar absolute privilege, and that issue has reached their Supreme Court, and they did conclude that only a criminal defendant can breach it, and only on this incredibly high showing.
Right, and I don't think it would be every time.
It wouldn't be every time.
There would have to be a showing.
Case by case, exactly. Materially assist the defendant in that particular case. And they have taken the astonishing position, while we're on this point, in this case of, automatically when you have a criminal case, and especially when it's a homicide case, automatically their rights to search overcomes our privilege. That's just absurd. No court in the land has held that with respect to these privileges. But
They have some very specific duties when it comes to the defendant. If
Yes.
there's Brady material in there, Giglio material, and again, I don't know, because I don't know, there could be, there might not be,
Yes.
but that is very, very significant.
yes,
And Mr. Tellis would be entitled to that. I do not believe that if there was Brady or Giglio material in there, that the First Amendment privilege would overcome that. It just wouldn't. The Sixth Amendment and his right to a fair trial would probably be more important. However, there would be, it wouldn't be like it would just be given unfettered. There would be certain parameters, orders by the court about not disseminating, only being used for this purpose.
right. And when you set up a battle between constitutional rights like that, which is where this might lead,
Right.
it is case by case.
It
One has to be
absolutely.
recognized. And it has to be done, you have to winnow what you're talking about to the smallest thing, because each person does have a constitutional right. So let's not talk about the whole kahuna and rule all for one people, on one side versus the other. Let's winnow this thing down to this, let's even see if there's a dispute.
And it's going to have to be very specific material. Because when this material is searched, there's going to be news gathering information, and there's going to be not news gathering
Yes.
information. And then that news gathering information, that's going to be the information that becomes, real important. Because the other information, Metro and the state can just have, because it won't be
Yes.
subject to any privilege.
Exactly, and we have said that. We said that from the beginning. Look, anything on there where we don't even claim a privilege in, now let's just look at the stuff that's privileged.
Right.
There's only going to be a subset of that has any relevance to the criminal case. They don't even want the rest of it, right? They shouldn't want it.
Right.
And they
It
shouldn't
wouldn't
be
be
entitled
relevant.
to it. So you winnow it down to there. Now you have what's relevant to the criminal case. Now you set up the constitutional battle between the Sixth Amendment and the First Amendment. So let's see let's narrow that further from relevance to Brady and Giglio material, right? Okay, now you have the battle properly set up. We got Brady and Giglio here, we got the First Amendment there, let's look in this particular case. How strong is the prosecution's case? How strong is the defendant's case without this evidence, right? So how much is it needed?
Well, there's that evidence, it goes. I mean, if the DA determines that there's Brady and Giglio material,
I
they have
know.
a duty to turn it over.
I understand how the law works when we don't have a First Amendment involved. There's an absolute duty, which by the way hasn't kicked in, so we don't know what's on there, right? And we won't know until a special master reviews it and says, this is Brady and Giglio material. Once you get to that point, we would be entitled under our protocol to argue, I understand this Brady and Giglio, and ordinarily it would be given over, but in this particular case, on these particular facts, given the public interest, the First Amendment outweighs. Do I think we would win? I don't know. I understand. I get it. That the Sixth Amendment right to the fair trial. It's one of the most
There would
important.
be specific, parameters where that information, it could be sealed by order of the court. The attorneys could be under a court order not to disseminate it to anyone in their office, no one. And if it was something that had to be presented at the time of trial, you could also seal that specific document as well to prevent it from becoming a public record and, blowing the privilege right open.
I agree. However, would you get,
Your Honor, we have a matter in front of Judge Schwartz where she trailed us all the way to the end of hers, and we just got a message.
Yeah, go ahead.
Okay, well, we
Go
got.
ahead, good luck.
I get to talk down there too. Thank you. You back.
so it sounds like to me, we can all agree, or at least some in the room agree, that we should have a review process that whittles down the material, which may get rid of this dispute, because frankly, the review journal may look at the privileged material and say, I know that it's privileged, but I could see how this would really help tell us in this defense, or I could see why this would be really material to the state in a prosecution. And so we're willing to waive it for this one case, right? It's their employee who was murdered. They have an interest in seeing justice done and having the right person convicted for that crime. So they may, the whole dispute could just go away after that special master protocol. But if it doesn't, you at least set up the rights of the parties. No party loses any rights going into that special master protocol, except we argue we are voluntarily relinquishing part of our rights because we have an absolute privilege. We have a privilege. We have a right to come in here and say, no, you don't even get that. But we've been always willing to just waive our rights to that extent, right? Then you have this privilege review protocol process, but, and this is the way it's set up, it doesn't just automatically end with the finding of Brady and Giglio material. It doesn't automatically go because of the state of the law in that, right? That we haven't ever had a Nevada Supreme Court decision ruling that our privilege is anything but absolute. We want to argue, we want to maintain the ability at that point.
We have to ignore Diaz, and I know you take the position that that's dicta, but I mean, they clearly laid out. Yeah, but you know what? If it was competing against a Sixth Amendment right to a fair trial, it would probably have to give way.
Right, but in the particular case. And so we just need to see, we need to clarify the issues more by getting to that point and understanding, well, what is it that we're talking about over here versus what is, and then it might even be, there could be in-camera reviews that could be appropriate to sorting it out in a particular case. But until you get there, you just can't get to that point with
Until someone looks at everything.
until someone who is not the people who could be the confidential sources or, directly connected to them, and even after that, just anyone, because privileged information, looking at it. And so our protocol, we actually, it's in the record, a proposed protocol order. We've consulted the Rule 53 on special masters. I believe it complies with all, there's a lot of little requirements in there. It complies with all the requirements of Rule 53. And what it does is it preserves every party's right until the very end, and then every party has the right to come back to you and say, okay, here we are, now here's what we're arguing. They are or are not entitled to see, and they get to argue this is why we're entitled to see it. And hopefully, we would never have to come back in here again because it would just eliminate the dispute entirely.
That would be nice.
That would be nice, right? And so let's, I don't know if you're ready to proceed to the motion for sanctions, but
Sure.
I am.
I know what the issue is.
Okay.
Is that apparently Metro communicated that, none of these devices have been searched. But then when I released those search warrants, I went back and looked at that search warrant, and I could not tell if that meant they actually opened the phone and searched it, or did they subpoena the carrier of that phone and get data from that phone? I guess that would be searching that phone.
What you're
Anyway,
saying,
I couldn't tell because there was no specificity in that affidavit.
exactly, which is exactly why we did not rush into court the minute we saw that unredacted search warrant, which they claim we should have done. They claim, oh, you've waived your rights to move for sanctions now because a month and a half has passed. Guess why we waited? Exactly the thing that you're saying.
But by the time that, if that device was searched, they had a court order, a lawful court order allowing them to, right? Before the RJ got involved.
No.
Yes, there was a search warrant.
There was a search warrant. They seized. So
Right.
my understanding is
Judge
during
Barham
the
signed
investigation, they go to the house, they find Mr. Gehrman, they seize his devices and his computer right then. Which I'm not a criminal lawyer, and now I wish my criminal lawyers were here, but my understanding is that's appropriate, right? You can get,
Sure.
after the fact, okay, that was fine.
Right.
Even though it violated that federal law,
To
right?
seize it.
Okay. Our position is it violated the federal law, so it was an unlawful seizure, but just setting that aside for the moment. That was on September 2nd, or September 3rd, I believe, is when they discovered the crime. And we know that they searched the phone between then and September 7th.
Right.
Because it was September 7th where it says legally obtained data from Gehrman's phone. That's the sum total of what it says. Then, that was a Wednesday. The next Monday, the 12th, they came, I believe, to this court and submitted the search warrant that gives them authorization to now go and search those devices. You can seize them, but you can't search them until you get that warrant.
Okay, was that warrant signed?
That warrant was signed on the 12th. And the
To
return
actually search the phone?
to actually search the phone and a whole bunch of other stuff, not just the 6 seized devices in this case, in this, return of property action, but a bunch of Telesys devices and other devices they had obtained. So they got that, they represented to this court, hey, we have these 36 devices and now we want to go search them. And they represented that on the 12th, even though they had already searched the phone on the 7th or earlier. Then,
Well, that's why I want clarification.
I wanted
Because
it
it
too and
says
haven't
data
gotten
from
it.
the phone.
I haven't gotten it. We asked for this, well, let me finish the warrant point. The return on the warrant came the same day, I believe, filed the same day, and they went and searched stuff, and all that says, it's like a sentence, and it says, one or more of these 36 devices has been searched. That tells us nothing, and I think, the property owner has a right to know what was searched or taken. And so, you could look at this through that lens, right? We need an inventory of what was on there. If that's what you're talking about, was one of these 60 devices. But so then you have that on the 12th, and then that was a Monday, and then that Friday, Metro and the state represented in writing, the in-house counsel for the Review Journal, that no search of Mr. Gehrman's materials has commenced. And they had been talking now for 2 weeks, since the very beginning, since September 6th or 7th, about the fact that they have the devices. In fact, then Sheriff Lombardo himself and DA Wilson himself independently called Glenn Cook, the executive editor of the Review Journal, to tell them, guys, we have these devices, we understand there's new gathered material on there, we really want your permission to search this, and they gave them an order to sign, and they were like, no, you don't understand the importance of this, we're not signing that thing to let you go search this, and off we are onto the races of this dispute, right? That happened on the 7th. So it was already up at the top levels of both of those organizations on the 7th. When they're submitting, which is the date, and they're submitting a search warrant saying, we searched, legally obtained data from Garen's phone. So when we get knowledge of this in mid-October, because the warrant's unredacted, we take very careful steps. We could not, it was astonishing, really. It was like one of those, what? Kind of like, we were just taken aback by the warrant. Because the language also, as it should be, was very carefully written back on the 16th, right? No searches commenced. So we thought, we are missing something here. Maybe what the detective was talking about was something like those other warrants that you try to get for cell phone data or for the telephone company, to get the calls in and out. Maybe it's fingerprints. Maybe that's, a detective's data if they're referring to fingerprints on the phone. We didn't know. So we sent a letter saying, laying it all out and saying, please tell us what this was referring to. And radio silence, 0. Not even a response to the letter. We had 3 briefs due. That was like November 23rd. November 28th, we had 3 briefs due in this case. 2 to the Nevada Supreme Court and 2 appeals that were going on then, that have now been consolidated, 1 in this court. We wanted to know the answer because it might have informed those briefs. So we reached out again by email on the 28th and said, can you respond to our letter of the 28th? Again, not even the courtesy of a response. Not that day, not any day. We're in court on December 1st for the motion to resign. After that hearing, out in the hallway, that's when we learned. And it was only because I approached counsel and said,
No, you knew back in October because Mr. Chesnoff called Metro.
no, that was Mr. Chesnoff called when it was not even fully unredacted. It said, based on data obtained from blank's phone. That's when we had the freak out moment of, wait, it seems contextually like that has to be Mr. Cameron's phone. So we made the call. Again, we presume that they're being honest with us. So we thought, boy, did a detective not tell in-house counsel for Metro the right thing? So it was a professional courtesy that Mr. Chesnoff decided to tell them, by the way, have you seen that redacted warrant? Like, you might want to go check in on that, because you told us the opposite. We never even, you would think in that situation you would get a call back confirming one, no call back, no call confirming, right? So then, by virtue of court process, we get an unredacted warrant. Now we know it's Gierman's phone. We still don't presume there was a misrepresentation made because we don't, we're careful, we're prudent, we're trying to be respectful. So we say, what, can you tell us what this means? Don't tell us what it means on the 23rd. Don't tell us on the 28th on the email. We file our 3 briefs. Now we're in court. After court, we say, when are you going to respond and tell us what they're talking about there? What kind of data was seen on Mr. Gierman's phone? What are you referring to there? It was only in the hallway that it was told to us, well, yeah, it was searched. You knew that a month and a half ago when Mr. Chesnoff called. And I didn't understand your letter. Well, what did you not understand about it? We laid out. We didn't understand what can be the data. Tell us what the data is that you're talking about. So there's just been, and Your Honor, that piece of this story really informs the fee request because, the other 2 sanctions we're seeking are sort of
You say they're not case-ending sanctions, but you repeatedly call them case-ending sanctions in your moving pleading. So I was confused in the reply when you kept saying, Well, they're not case-ending sanctions.
I'm going to take the heat for that and say that was editing sloppiness on my part.
No problem.
Because it is case ending with respect to a party. It is
Right,
not
but the problem
case
is,
ending.
case-ending sanctions in this case affect a criminal case.
Yes.
A first-degree murder case. So that is very significant.
I don't underestimate the significance of that, and I apologize for the confusion on the terminology. And it would be case concluding within our civil return of property action with respect to 2 of the 3 defendants in this action, right? That's our biggest sanction that we're requesting is, look, this is,
So Mr. Tellis would be able to review the evidence and decide what the state could use to prosecute him?
no.
I mean, that's absurd.
It seems absurd so to me too, because, you're thinking about
Well,
this.
yeah, it is absurd.
But Tellis could also argue, he could come to you and say, look, I know they're pleading God-stricken, but I want to see this stuff. And the only way for me to see this stuff is for them to know whether it's Brady or Giglio. So I, Mr. Tellis, am asking you to rule that they can look at it. We're not obstructing him from arguing that, and, he can argue that. And you can order that. What we think
And I
is
would be
appropriate.
summarily reversed by the Nevada Supreme Court. I allowed a defendant in a criminal case to decide what evidence the state could use in their prosecution against him.
No.
I mean, it's just, it's.
That's not what I'm saying, Your Honor. You're
It doesn't
misunderstanding.
make sense.
You're misunderstanding me then. Mr. Tellis wouldn't be deciding what evidence could be used in
Sure he
this
would,
case.
because you're saying he'd be able to decide whether the state saw it or not. So if he says, no, the state can't see it, because I'm good, then he would be deciding what evidence the state would be able to present against him in a murder prosecution.
No, because we are asking for the implementation of the protocol, and always have been. So even if you enter the case
But
concluding
why is
sanction
ordering a
now.
special master a sanction?
Well, look, it should just be the relief that's granted in this case. That's why it's the alternative sanction. The alternative sanction is entry of the protocol order. It's not really sanctioning anybody. That's why you need something punitive. And the punitive piece is, all right, you guys don't get to talk anymore. Okay? The review journal gets to talk, and Mr. Tellis gets to talk. And Mr. Tellis understands how the criminal process works. His lawyers get it. They can argue for you to get your stuff too, or look at it in order to give him his Brady stuff. But you cannot talk anymore because you have, misrepresented facts to a party. You have misrepresented it to court. You have allowed that misperception to perpetuate for months. You have allowed this party to spend hundreds of thousands of dollars based on a false premise that you could have corrected long, that really should never have been made, right? That again, highest levels of the department, the sheriff himself, the DA himself are concerned about this. So when we were saying, we want a commitment that you haven't searched it yet before I go on vacation, this is in-house counsel for the review journal, you would think that they would take the care that would be necessitated under those circumstances to go and get the right information, right, to tell us, yes, it has been searched, or no, it hasn't. So, the notion that, and they haven't even asserted that there was a miscommunication. They just say, oh, there's no evidence there hasn't been a miscommunication. Well, that's like a little bit, I don't even know how to describe that. That is far-fetched. It's far-fetched to think that there was a miscommunication. But even assuming there was, once we knew and we told them, we know you searched the phone and you got to tell us what's on the phone, they completely ignored us, didn't give us any information about what was on the phone, didn't give us a chance to understand the extent of the prejudice we had suffered. I don't know whether there are confidential sources who have been burned. And in fact, we're going to need the injunctive relief to be amended to prohibit dissemination of anything that they saw on the phone, but we can leave that for the moment. But the basis for the strong punitive sanctions we've requested is in large part due to, that continuing, just misrepresentations to the court. They did not correct the record. And hundreds of thousands of dollars were spent from that time forward. And
I'm gonna have to hear from the defense, because I'm gonna have a jury panel coming in.
Okay.
So I do want to be able to hear from Metro's counsel, and I am going to ask for an explanation regarding that phone. What was searched? Has it been searched? What was searched? And what has happened with that information?
And what is it? I mean, we asked for, confidentially to us, what is it that, because of the privilege, of the stuff that
Based on the
could be together?
things, it appears to me as though those 6 devices, there's a digital record, or I guess a digital duplicate of all those devices have been made. Is that correct?
That's right, Your Honor.
Okay.
Which we informed them of in October. Well, yeah, early October, when we had one of our many meetings with them.
But that's beside the point, right? That's just a standard, as I understand it, par for the course, when you have a seized device, for chain of custody and evidentiary reasons, you make a copy, right? Point is, whether they search the copy or the original, I don't care, they search the phone.
Well, no, I'm going to ask. I want an explanation for that. So I want to hear from Metro now.
Okay.
Why don't we start out with that? What is that with that phone?
Well, Your Honor, I've explained this to them on December 1st, as best I could. This is what,
I mean, I don't think you misrepresented. I don't think there was any
Thank you, Your Honor.
intentional misrepresentation. That's not what it appears to me.
of course I didn't misrepresent anything. Why would I? Why would I purposely misrepresent anything to them on September 16th? If I had known, and this is what I told them on December 1st in the hallway, if I had known what I know now, I would have not written that email in the manner that I wrote it.
How did you not know that?
Because the information that I had was that the homicide section has not conducted the search that they need to conduct
Okay.
on any of the 6 devices. The homicide section needed at that time, and they need to still, at this time, conduct the search that they need to conduct. The comprehensive, complete search of those materials.
Well, what
and
was that in that affidavit that was given to the judge for the warrant? Because it does say
It says data.
legally obtained data.
It does.
That's why I know that can mean a lot of things. It doesn't necessarily
I don't-
mean that the phone was searched.
And what I told them on December 1st was that I don't know what the data was. I didn't sign the warrant. And they wanted me to go and figure out what the data is and relay that information to them. And what I said was, that is going to be attorney-client privilege, and isn't that going to be a violation of the injunction? We've promised.
Have they searched the phone?
There was a preliminary search of the phone in the days, which is exactly what I told them on December 1st. The preliminary search of the phone in the immediate aftermath of finding the body. And that was what I didn't understand. The homicide section did not do that. The homicide section still needs to conduct their search.
Who did that then? Who did the preliminary?
It was not the homicide section.
Who was it then?
It was a different detective.
It's not on homicide?
No. And again,
Why
now.
was he or she involved? I don't get it. How would they even be involved in a homicide investigation?
My understanding now is that there are, there's other people involved. This is a big case, so there's other people involved, Your Honor. So now, again, we're getting into my understanding of an open criminal investigation and information that I learned from my clients. So I'm not comfortable
Well, this
with.
is public. It's in an affidavit that's been made public.
I don't know what
For a search warrant.
I don't know what the data is. What I know, though, is that the homicide section has not conducted their search.
Okay,
And
so
so
when
when I
asked
read-
homicide, they said, no, we haven't conducted our search.
That's right. So the information I relayed on that day was my understanding at that time. Now, I then was contacted by Mr. Chesnoff, who was very nice to call me, because he said that they had gotten a search warrant unsealed, and it appeared to him that the phone had been searched. He wanted to give me professional courtesy to let me know about that. The impression I was getting was that this was a favor to me, that he was letting me know this so that I would know it, because in the coming days, we were going to be back in court in front of Judge Johnson, and that this was going to be, I was going to be confronted with this information. And he didn't want me to be blindsided by it. That was my understanding of what he was trying to get at. So we were in court a couple days later, and this was nobody ever brought this up. And no one has ever brought it up until the day before Thanksgiving, when Ms. Kissinger sent me the letter demanding to know all the details about everything. It came, the Wednesday before Thanksgiving, and it demanded a response by noon on the Monday after Thanksgiving. And we were in court later that week. So I happily spoke to them after court that week, and I relayed as much information to them as I felt that I appropriately could and that I even knew. So the point, though, Your Honor, is that the email that I sent on September 16th the vast majority of it remains true. We haven't searched the 5 devices at all. None of the 6 devices have been searched by the homicide section. That was the commitment that I made in that email. So the other issue here, Your Honor, is how they're saying they freaked out on October 13th. Why did they wait for 6 weeks to approach me about this? If it was so important to the case and it totally changed everything so completely, why did they not email me? Why did they not call me? Why did not? They're very good at that, writing me letters and sending me emails, but they never did. So my understanding is they
There
knew.
was a lawfully signed search warrant allowing for the search of that phone. Is that correct?
Yes. And Your Honor, for clarity there, that's the DFL search warrant. That's the Digital Forensic Lab search warrant that they always get when it's electronic devices.
Do you want to be heard further?
On this issue of the sanctions,
Well,
I mean,
your
obviously-
opposition to these motions.
well, it's hard to know where to begin, Your Honor. I mean, there's so many issues here, but really it does boil down to some very simple things. And maybe I can take
Well,
a
let me
step
ask
back.
you what you think. Do you think the privilege died with Mr. Gehrman? Or
I-
if it didn't, who gets to assert it?
This is what I think, Your Honor, and this is what the issue has been all along. None of us have ever said.
Because it can't possibly be gone. That
Well-
doesn't make sense to me.
This is why we've been asking for them to agree to a protective order all along. The issue in this case has always been pretty
Well, do you
straightforward.
object to having a special master review
Yes.
the...
Yes.
Oh, okay.
And this is why we need a judge, and this is why we needed a judge since the beginning. But the problem has been we've been in front of the wrong judge. So that's created a whole legal sideshow. And again, if Your Honor wants to get into that, we're obviously, I think that's important. But the overall issue, Your Honor, is we believe that the Brady obligation is very strong. The state understands its obligation. These devices are in the possession of law enforcement, and any Brady material on them must be turned over to the defense. The defense knows that we're in possession of these devices and has demanded to be able to review them.
Also, Mr. Helmut has made a demand to review...
Mr. Kane did, for sure.
Oh, Mr. Kane.
Mr. Kane did, for sure. He made that demand not only to us personally, but on the record. He insisted that he be able to see everything on the devices. The issue became, this constitutional obligation is very strong. It's very high. The RJ's interest is lower. I don't think there's much of an interest at all, and this, what the briefing has also been about. But if
Well,
anything...
I'm kind of concerned about, confidential sources being burned, and specifically in this case, I mean, wouldn't you agree, there's probably people from that office that were talking to him. It's pretty obvious that there was, from the public administrator's office.
Sure. And what Mr. Kane said, and how can anyone disagree, that would be directly relevant. If all the confidential sources we're talking about, the ones at the public administrator's office would be the most likely candidates for material that must be turned over to Mr. Tellis. Interestingly, you've heard Ms. Kissinger talk about the affidavits that they have submitted. The only specific information that they're aware of that they fear is on any of these devices are from the Public Administration Office. There's no other specific story that they know about that he was working on, no other specific confidential sources that they've been able to talk about or mention whatsoever. The only
That's what
specificity...
no one knows.
Agreed, Your Honor, agreed. So the point is,
There's a high probability
Who-
there'll be news gathering information. Do you agree with that?
yes, I do agree with that. And we've never discounted that. We've never told the RJ that their rights are inconsequential or that the interest of the media is inconsequential. And we've certainly never said that the rights of confidential informants are unsubstantial. We
Because there
protect...
could be some sources from inside Metro and other sources, right?
That's what they say. That's what they say. So the question has always been, who is going to conduct the search?
He's an investigative reporter.
Exactly.
He worked on,
Exactly.
really good stuff.
And the murder trial will be about that, apparently. So again, this is a very unique circumstance. So it came down to who is going to conduct the search. The position of the state and Metro and Mr. Tullis was that only they could conduct the search because only they know what's Brady material. Only they know what's relevant in the case. Delegating that responsibility to anybody else opens the door to a situation in the future where there could be something that wasn't turned over to the defense that should have been. So our position all along has been that we need to conduct the search. We are the ones that know what this case is about. The RJ's position,
Who is we?
the Metro detectives,
The two homicide detectives?
right, the two district attorneys, and at the time it was Mr. Kane and his associate or his co-counsel. So, because those are the people that know what they're looking for. Delegating it to somebody else means that you have to convey to the other person what you think is going to be relevant in the case. And it opens the door that something won't be produced. So our position has been that we need to conduct the search. The RJ's position has been absolutely never will they ever allow anyone from the side of the table to conduct the search. They have only wanted a special master to be able to conduct the search. They believe that the special master can determine what's Brady material and what Mr. Pellis might be interested in. And that will be the person that will sort out what's relevant and what's not relevant. So that was where the impasse came, Your Honor. And to be clear, it was the DA and Metro that even informed the RJ in the first place that this issue even existed and that these devices had been seized. We reached out to them to engage them in a conversation about this. We arranged for a meeting with Chief Judge Jones to see if this could be worked out.
You asked them to sign a consent to search.
We did.
So I have to believe that you think there's a high probability that there will be First Amendment protected information on there.
We understand that the rights of everybody have to be protected. And in an abundance of caution, sure. I mean, it would be better to engage with the RJ and see if we can reach an agreement on this issue before proceeding. That would be the prudent way to proceed. So that's what we did. But what happened was...
Because now there's an injunction in place,
Right.
and a murder investigation has come to a screeching halt.
Right.
Which, that's not good public policy.
No.
It just doesn't make sense.
Couldn't agree anymore, Your Honor. Couldn't agree anymore. So the question has been, who's going to do the search, which requires a judge to determine and to balance everyone's interests and to come up with the remedy. Because we can't agree to a remedy, even though we tried really hard to. Then the issue became the forum for resolving this. And that's where we get into this motion for return of property. The motion for return of property was never a proper vehicle for this. There's no
Well, I
jurisdiction.
wondered, I didn't know what other vehicle, I mean, because they have used that statute for return of property, and that, I mean, that's concerning to me too, because they're not even contending that the property,
Right.
they're not contending an ownership or possessory interest in the property, and the remedy in that statute is give the property back.
Right.
But that's not what they're asking for.
They never have been asking for the return of the property. They know they can't have the property back. The property is the estate's property. So the vehicle that they've been using since the commencement of this civil lawsuit has never been the appropriate procedure.
Well, what do you think the appropriate procedure should have been?
Well, I never thought they were going to file a motion for return of property, but if they were going to file a motion for return of property, it would have needed to be in front of Judge Heron at that time, because that's where the criminal case was. I thought what they were
Well,
going
you
to
know,
do.
we file this if there's not a criminal proceeding pending, right? I mean, the statute says you file this if there's
Yeah.
not a criminal proceeding pending. And it
Yes.
appears to me there was not a criminal proceeding pending in this court when it was filed.
Right, there
The
was a.
grand jury hadn't come back yet.
That's right. There was a criminal proceeding pending in justice court. So, but let's back up a little bit
Did
because,
she decide she did not have jurisdiction to hear this?
right, but
Okay.
this is really important, you know.
Oh,
The motion they filed in front of the justice court was not a motion for return of property.
what was it?
They called it a motion for protective order. Motion for protective order. The goal at that moment in time was to disrupt the meeting that the DA had arranged with Judge Jones. They did not want
You
that.
weren't gonna go meet ex parte with her.
No, they were
I mean,
invited.
if they didn't want to go, or if they didn't agree to it, you weren't still going to go, were you?
I don't know. Well, it never happened.
Because they didn't need to obstruct, they just had to say, we don't agree, we're not going.
I think it's absurd to think that Judge Jones would enter an order ex parte,
She wouldn't.
knowing that they had claimed this interest, and the whole reason that the meeting was set up was to discuss their interest. So, and to discuss what to do next. So they did not want that meeting to happen. They've never explained why. So the only thing they could do or think of doing at that moment was to file a motion in front of the justice court. 2 days
Well, I wouldn't
later,
have wanted to take that meeting. I mean, you have all these important issues without any briefing or any notice of what's going to be brought in front of you. That might have been the reason. I mean,
Well-
these are pretty significant issues,
they are.
and it's not something you're just going to know off the top of your head.
Well, but the meeting wasn't going to be a disposition of anything. It was
So
designed
then what was
to,
it going to be?
it was going to be a discussion.
About what you
And-
should do with these devices, how they
Right.
should be searched, whether there should be a protective order.
Well, and whatever the remedy would be, however the search protocol would be. And that was also what I represented in the search on the 16th of September. We're not going to proceed unless we have some kind of court approval. So, I mean, to me, this is an absolute measure of good faith. Let's sit down with the chief judge, who's one of the homicide trial judges, and see what she thinks. There's no, it's not a motion, it's not, sticking an order in front of her. Nobody would ever have expected that. It was just a meeting to have with her. They knew it was just a meeting because that's what the letters that came back to us described it as, a discussion. They didn't, for whatever reason, wanted to have that discussion, so they filed a motion for protective order in the justice court. 2 days later, the justice court decided that it didn't have jurisdiction to enter a protective order. But the meeting was canceled because the RJ was on the record of saying that it was inappropriate to have a meeting with Judge Jones. So that whole idea wasn't going to work. So we had various meetings with them, and it was clear that we were having an impasse, which was whatever we described. We want to search the phones ourselves, or the devices ourselves, and the RJ doesn't want to let us search the devices ourselves. They only will agree to a special master. So we were having an impasse, and the next thing they did was they filed a motion for return of property in district court. And that's been, I think, the main reason we've been having so much litigation, because The concern on our end is that if there's no jurisdiction to have filed a separate civil action seeking equitable relief because there's already a criminal matter pending, then any
Well, the
order...
RJ intervened in that matter.
The-
You know that, right? The RJ intervened in the criminal matter.
Yes.
They did the search warrant.
Yes, absolutely.
And I'm just saying, they knew how to intervene.
I know. Well, that's exactly right, Your Honor. So the vehicle that's being used is not appropriate, and this is a really important problem, because if a judge decides exactly what the search protocol is going to be, and it's not Your Honor, then there's always going to be this jurisdictional problem from now until who knows when, right? If there's no jurisdiction to enter the order, then it should not be entered. And a motion for return of property is filed in the criminal case if one is pending. But they didn't do that. So when we were in front of Judge Johnson, because this was being treated like a freestanding, independent civil lawsuit for equitable relief, Judge Johnson knew that the Justice Court had decided that it didn't have jurisdiction. So at that moment in time, the criminal case was still in Justice Court. So it was at that moment in time that Judge Johnson decided to issue the preliminary injunction. Within a couple of days after that, the indictment came, and now the criminal matter is before Your Honor. So what we've been saying all along is that this should be heard by you. This is evidence in the homicide case, and we can't have Judge Johnson telling us to do X, Y, and Z, where Your Honor would want us to do something different. So most of this litigation has been trying to get this case in front of Your Honor. And I realize how complicated that has become and that it is now. But the RJ fought tooth and nail to have this case in front of Your Honor. When I asked Judge Weiss to transfer the case here, it was judge shopping. It was litigation tactics. No acknowledgement that it would be a prudent course of action for us all just to agree that we should let you hear this and dispose of it and tell us what you want us to do in terms of the search protocol. So when I see this motion for sanctions and I hear that our homicide detectives can't be trusted even with a protective order, or that Ms. Weckerly is now inclined to figure out who all the confidential sources are and then start telling everybody, versus some special master would not do that. Why? Someone has to look at these devices. Why is any one person more inclined to reveal confidential sources than anyone else? So that is why our position has been that a protective order is more than sufficient to deal with this issue. Their rights
the
are...
issue of the preliminary injunction is now up on appeal.
Yes.
And today, what's in front of me, I believe, is either a new one or the extension of it as to Mr. Gehrman's car,
That's right.
and then the motion for sanctions.
Right. Well,
So,
there's counter motions.
and you think I can rule on the motion to dissolve?
Yes.
Even though it's up on review right now?
I think you can indicate a ruling.
Well, I guess you're right, because that's what I have to do on the
Right.
car, too.
I think you can indicate
I'd have
a
to
ruling.
indicate a ruling, then they would have to
Right.
issue a remitter.
That's right. And I believe it's prudent and necessary for you to assess what your own jurisdiction is as the judge sitting as presiding over the civil matter. Because these injunctions are in the civil case. The sanctions are requested in the civil
Right now in the
case.
civil case, but they are enjoining an investigation in a criminal
Right.
case.
Right. So what I think would be the best course of action, Your Honor, is what I tried to outline, I think, in our reply. The court should look at all of this and see that this freestanding civil case is not appropriate. It doesn't mean that the RJ can't be heard. It doesn't mean that the rights, if they have any, are being discounted. It doesn't mean that they're not going to, that they can't come into the criminal case and be heard. But the venue to dispose of this is the criminal case. That's where the record for Mr. Tellis needs to be. That's where these decisions need to be made. That's where orders need to be. That's the only prudent way to proceed. So what I'm asking is that the court look very carefully at jurisdiction, decide that preliminary injunctions, separate civil lawsuits are not the appropriate way procedurally to proceed. Indicate that.
But you're not indicating they don't have the right and opportunity to be heard.
No, I never have. Again, this is why we engaged with them. This is why we asked them to come to a meeting with Judge Jones.
So then you must agree that their assertion of the privilege is appropriate?
No, well, I believe that their rights are minimal if they use this at all.
I believe the privilege belongs to the reporter. And that the reporter, the news gatherer,
Right.
that person has to assert the privilege. But we have a corporate entity here.
Right.
Well, you know what, I guess we have individual reporters.
Right, right.
They're part of this, correct?
Yes,
Individual reporters that indicated that they did news gathering with him and that information might be
Right.
on there. So I guess that issue might be
well,
resolved with
and,
that.
right, and the reason that it's important to evaluate the RJ's rights or any of the other plaintiffs that they're trying to add into the civil case, the reason it's important to evaluate that is because I think it goes to what the remedy is. If they have these tremendously substantial rights, then maybe they would be right. Maybe a special master would be the more appropriate remedy in comparison to Mr. Tellis' rights. But if their rights are not substantial because we never took anything from them, we didn't execute a search warrant at the offices of the RJ or against any of these plaintiffs that they're trying to add to the case.
Was there any RJ property at his home that detectives said, oh, you know what, we don't want to touch that because we think it might be property of the Review Journal? I'm just curious.
I don't know that specifically, but I do
Okay.
know that there were papers that were left there. Because very early on, when we were trying to work this out, I was asked whether there were any, if we took any papers, and we haven't. It's my understanding. So, yeah, again, Your Honor, it's for a judge to decide what level of rights that they have. I think they're very low, and for that reason, it's less appropriate to disallow Metro from conducting its investigation or the state from doing what it would normally do. If we had gone to the RJ and taken things from reporters that are at the RJ, then their rights would be much more clear. Their standing would be much more obvious. That's never been the case here because of what occurred. As Your Honor knows, we took devices from the victim of a homicide who was allegedly killed by someone who was who was being written
With the
about.
subject.
The subject of stories. So this is not a normal case where some civil litigants want to depose a reporter and the reporter objects to the deposition or is called in trial and there's an objection to it. This is absolutely completely different than that, right? So
And I agree, it's a very,
yeah.
very unique set of facts.
But there are counter motions before Your Honor. There's always
I know there's the counter motion to dissolve, but you believe that I could make an indication I'd be inclined to do that if the Supreme Court issued the remitter?
yes. But it would be in conjunction with entering some order in the criminal case at the same moment. So there's no injunction. It's not like you're going to do exactly what I want and then we're going to start searching the phone. There's an injunction in place. What we're looking for
Because
is
you at least agree there has to be some protocol in place.
yes, of course.
And a protective order for sure to prevent the
Yes.
dissemination of any of this information.
Absolutely.
Once we decide what the news gathering information is.
We've never suggested that that everyone at Metro should be allowed to look at these devices.
Well, if there's no protective order in place, that could happen.
That's right, and so that's why we've always suggested to the RJ to try to balance this out and make it where the investigation can proceed, but to protect any interest that RJ or any of his employees may have, that there would be a protective order entered.
Where's Mr. Gammon's car?
As far as I know,
Did Metro seize the
No.
car? Okay, that's why I thought you probably wouldn't even,
no,
so you have no desire to go search the car?
no,
Okay.
that's my understanding, Your Honor.
Ms. Weckerly? I want to make sure that's,
Your Honor, I'll be really brief. Obviously, the state has very big concerns about the appellate record in this case. We want Mr. Tellis to have no filter between himself and any potentially exculpatory information. It's not on the defendant to tell anybody, let alone the state or some special master, what the anticipated defense is going to be. He's entitled to not only exculpatory information, but anything that might lead to exculpatory information. Having no idea, to me, what's on the devices or what the defense is going to be. I have a lot of concerns about him not having direct access to potentially exculpatory information, and I certainly have never seen a case where there's some filtration or threshold that has to be met in terms of evidence before exculpatory information is turned over to the defendant.
right, I mean, the state determines what is exculpatory and what has to be turned over. But then there's also impeachment evidence too, based on, and I don't know who the witnesses are going to
There could
be.
be alternative suspects, and I mean, there could be all kinds of things, but like, he does not have to tell us what he's looking for. We have to give over what is potentially exculpatory.
Your Honor, we've really tried to explain that.
But Ms. Weckerly, you don't want to search Mr. Gammon's car?
I don't think that there's a basis for us to do that. I mean, obviously, we can talk to the defense counsel if they want access to it or something like that, but I think the place where I think there is potentially exculpatory information is in these devices, if there is.
Again, Your Honor, we really tried to explain that this is creating appellate problems if we can't have access to this material. That's
Like I said, it's brought a murder investigation to a halt.
right. Absolutely, Your Honor. I don't know if Your Honor has any questions for me specifically.
No, and
I
I've
mean-
got the jury panel week now, so I'm going to have to wind it down. I don't know if the RJ wants to be heard.
Please have in camera, please.
I have just a couple minutes because I have a jury panel waiting outside.
Understood, Your Honor. I will try to move quickly. I want to speak first to the appellate issues that have been raised.
But they're talking about appellate issues relevant to the defendant in the criminal case.
I understand. They don't want an appellate issue causing a problem in the criminal.
If he's convicted, yeah.
Correct.
They don't want post-conviction issues.
I understand, but it's a red herring because privilege reviews happen in criminal cases all the time. Sometimes the privilege review is done by the judge. The judge has to look at evidence to determine whether or not it's Brady. Okay? In regular criminal cases, the criminal defendant does not have a right to just look at all the evidence in the possession of the prosecution, which is
I
what
agree
they're
with that.
asking
I'm
for.
sure the prosecution would agree with that too.
They haven't agreed with it.
They
don't
have
agree.
to turn over stuff that's statutorily required based
Right.
on our statutes, and they have to turn over Brady and Giglio, that
Yeah.
type of information.
But they are
don't have
going
to turn over everything.
They're taking in possession, they have to, that Mr. Tellis and his representatives are entitled to look at all of this material at the same moment they are. Because of Brady.
I don't agree with that. I don't agree with
And
that.
my criminal defense counsel is blown away by
Yeah,
that
but
as
if
well.
he was over here, he'd be saying he wants to look at everything.
No,
I'm just kidding.
Your Honor.
It's a little joke.
how many times,
Just
Your
kidding.
How many times, Your Honor, has there been a dispute on discovery, and it gets submitted to the judge to make a judgment as to whether it's Brady? This concept that you just dump everything on the defendant, or a guy like David Roger doesn't know what Brady is, that their argument, it falls flat.
Well, he
Your Honor.
may not know what Brady is because he doesn't have access to all the investigative material. I mean, the stuff I heard in the media that was public and reported versus what I read in the search warrants was drastically different. You know, there was just way more information when those search warrants came to light.
Well, Your Honor, I mean, if there's a question about whether the special masters could adequately do their job, I mean, we could talk about adjustments to the protocol that we could come up with to account for that. Nobody suggested that, and we'd be amenable to discussing that. But, you know, this notion that anything that's going on here is going to affect the appeal is silly, because courts recognize the ability of special masters who are agents of the court, right? And would be doing just the same thing that the court would be doing, but it's going to take them more time, so you're going to have them do it. And the special circumstance that in your courthouse we have special, confidential sources. That stuff happens in criminal cases. It's not going to be a basis for appellate review. So that's a red herring. There's just a lot to say here. On the jurisdictional point, there is no jurisdictional argument to be had. He hadn't been indicted at the time that we brought this.
No, I think the statute does allow you when there's not a criminal proceeding pending. It appeared to me there was not a criminal proceeding pending, so it was the appropriate avenue. But you're never going to ask the court, hey, when this is all over, return those devices to us.
Not the devices. We have asked for a return of the news gathering, non-physical material.
I don't think our statute defines property in that way, especially when you look at Rule 41G in the federal courts, where it specifically does cover this. If our legislature wants to include that, then they need to amend that statute so it's very clear that it would include intangible data,
It does.
Information.
It does in the property of attorney provision, which speaks about just an analogous privilege. So it's right in the statute, and I wish I had it in hand, but that is not a concern. And, this issue about what gets returned to us or not, that can wait. That can wait till the end of the protocol. We're not asking for anything to be returned right now.
But if you don't have jurisdiction or standing to bring a motion for return of property, then you have no standing to ask for relief.
But the return of property statute does define property in a different way when you're talking about privileged materials. And it would just analogously apply to this privilege. I mean, that is right in its house privilege, priest penitent privilege, reporter's privilege, and just talk about the attorney's client privilege, because that's the one that's always an issue in criminal cases. But the same rationale applies here. And it does say intangible. I think it uses the word intangible.
It's tangible.
No. There's two definitions. There's one that applies to most of the return of property statute. Then there's another one that applies specifically to the return of attorney property provisions.
All right, so you want me to interpret that the legislature meant to, make that be the definition for
all
First Amendment?
Yes. I mean, we would have to do that, yes. And I think under, let's say we didn't even have a statute. There were courts had equitable jurisdiction to seek return of property without statute, right? In the federal court, they do it by a rule. So you have jurisdiction even regardless of that statute, but the statute provides.
I don't think he owns because clearly the RJ has his final product. You have it because it's been printed, right?
Yes,
but drafts and stuff like that, they belong to Mr. Gehrman, not the RJ.
No, they belong to the RJ. All of news gathered and anything created in the course and scope of employment. It's just the same as employment law, right? He creates all that stuff in the course of the scope of employment. So it is their property. It's also copyright. Copyright, they have said, that's just us to publish stuff. No, it isn't. The work made for hire provision in the Copyright Act makes clear that anything you do and create in the course and scope of your employment is covered by copyright.
So when a reporter leaves, the RJ gets all of that back from the reporter?
Yes. And it's never, it's never disputed. That's why you don't see cases about it. Like, that's just how it's done. So, yes, they have property. It's also trade secret law protects that stuff because of the nature of it, right? confidential work product that leads to a published story, it's a trade secret. And all of that is in our brief. So there's definitely jurisdiction in terms of, do you have a right to seek a return of property? There's definitely standing to assert privilege. And this notion of jurisdiction.
Well, someone has to be able to assert that privilege. I don't know what our court will eventually say, but it can't possibly be that it dies if the reporter dies.
No, and again, I would encourage you to read the First Amendment privilege cases, Schoen versus Schoen, Farr versus Fitches, other ones, because it's typically and Las Vegas Sun. Again, we have a binding precedent on you that says that actually the newspaper gets to assert the privilege because they were.
And I think they said exactly the opposite. They told Mr. Greenspan, it's not yours, it's Clint Pruitt.
No, I was concerned about this, and I would encourage you to reread it.
Okay.
It's the paper. It's Greenspan. And it's either Greenspan or the brother or both. But regardless, it was, which is the publisher, and we have Keith Moyer, RJ's publisher, as a plaintiff. But definitely the Sun itself was a party, and relief was granted to the RJ. So I don't think you have to even be concerned about that because you have a precedent within our own state. On the point about, sounds like we don't need to talk about this criminal proceeding pending, but just so you know, you can look into criminal statutes and it makes clear there isn't a criminal proceeding until you have an indictment. I mean, there's even a statute that says the first pleading that is filed in a criminal case is the indictment. So there wasn't a criminal proceeding pending, and they're trying to make the case that, oh, well, now that there is, we got to change this whole lawsuit. No, the statute doesn't say that either. It says at the time that you file, it gets treated as a motion or a civil complaint seeking equitable relief. So that's where we are, because that's what we had to do. And by the way, we had to do it in this court, not in the justice court, like they say, because guess who issued the search warrant to seize the devices? This court. Judge Sierra Jones issued that warrant. And under the law of in-rem jurisdiction and under Nevada state search warrant law, the race comes back to her, this court. So this court holds jurisdiction over the property itself, and the return of property statute says you have to move in the jurisdiction where the property was.
Let me tell you, if you want to be heard further, I can continue this.
Okay.
Or I'm prepared to issue a ruling just because I've had that jury panel sitting out there for a minute now, and I don't like to, I hate to keep them waiting out there.
Yeah, okay. If you don't mind, just let me see if there's anything truly important to say to you.
I read all your pleadings.
Okay. It's important that it's the special masters versus them, because the special masters don't have a dog in the fight, right? They don't have people within their departments who are confidential sources. That's the key distinction as to why this is not like the ordinary case where you can trust these attorneys who appear before you all the time and trust the process to work, because there are institutional problems with the facts. And we remember that the public is watching. Are they going to trust this process? When they're the ones where there are confidential sources, you want the public to trust the process. And I think any order not other than a special master doing it would do damage just to the institution of the courts in Clark County, protecting the rights of people. So I could go on, but I'll sit down, except for one last one, I'm sorry. We heard that the car had not been seized. I'm wondering if the car had been searched.
Their own affidavits say that there's fingerprint
Right.
dust.
I mean, clearly we know that the outside was because there was fingerprint dust everywhere, which would make sense.
Yes.
So at a minimum, we all know that. I can't remember who represented that.
We did.
They did.
Okay.
Because it was.
Yeah, but there was fingerprint dust all over the vehicle.
Yes, and so so it was searched in some sense. But what I'm asking is the question about the kind of.
You want to know if they got that black box or the computer and searched that?
Yes. Can we have a representation today on that?
My understanding is no.
Okay. But there's no intent to do that?
Not that I know.
Okay. And if there is, you would bring that to the court?
Who knows where the car's at?
Well, that's what I was going to say. Is it with the, it would have to be because it would be owned by the estate now.
Yes, they could have sold it by now.
That's true.
I looked at the probate matter, they say it's a lease.
It's probate, it's in probate?
Yeah. And the car is
It's a leased
listed,
vehicle, then it probably went back to,
it could have been serviced, they could have driven it off to who knows where. That's another reason why I'm saying they have
you
no.
have no possession of the vehicle.
No, and they have no ability, they exercise no control over it either.
Nor do I think they have the authority to. It was
Right.
his vehicle based on the representation in the pleadings. It was Mr.
Right.
Garman's vehicle.
Right.
But the point being, Your Honor, nobody knows where the car is. And what's the harm to entering
Well,
that
it has to
injunction?
be with the estate.
But it was a leased vehicle, to your point. It might be, somebody else might be leasing it.
But that would be at the direction of the executor, right? The executor would have to turn in the vehicle or do whatever it is that would be done.
We had an investigation, Your Honor. We believe the car was returned.
That's what makes sense.
Yeah.
Returned to the leasing company.
Yeah.
Right?
The
That's what
dealership.
would make sense.
Yes. Which,
Who might be downloading all the Bluetooth information with all the confidential sources in it. And that's what I'm saying. They've exercised no control over
No, but
this
there's not even
vehicle.
any evidence that when he would get in his car, he would plug in his phone.
There's not.
Because you have to plug in the phone, or you have to have some sort of software that would allow that. And no
Right.
one's even said, and again, I go back to he was a very sophisticated, seasoned reporter. He probably didn't do that, because he knew that.
But Your Honor, the possibility exists. At this point, remember too, our second motion seeks not only the cars, but because of the problem of the investigation continuing, and I don't know what papers they're finding elsewhere and what they're bringing in, it's just a logical extension of the first injunction. Just protect the stuff that we know that could contain news gathering material. So there's a second category of
I would have never thought a car would contain
Well-
news gathering information, so I wouldn't even know how to articulate and make that order specific enough. But, I have a feeling that if the state finds any news gathering information, they're not gonna search it until they come get permission from the court.
Well, but one has already been searched again. So, and I would hope and trust that they wouldn't. But, they've taken very strong positions in this case that they have a right to search that stuff right now.
Well,
And
there's
so do I think they're
homicide
going
investigation.
Right. So do I think that they would be incentivized to go ahead if there wasn't an actual court order preventing them? I'm concerned about it. And so that's why we have filed the second motion, and it sounds like there's no harm to entering it because they don't even have any intent to search it, but it would make everything clear. And it would make it clear that if you bring anything else in, you can't search that either if it's news gathering material.
Okay, well, at this time, I'm inclined to deny any injunction as to the car, especially based on the representation that the car has gone back to the dealership. And I'm inclined to deny the motion for sanctions because it would affect the criminal case adversely, and I don't think that would be appropriate. And I would be inclined to dissolve the preliminary injunction and impose a protocol wherein a protective order would be in place in order to protect the rights of the parties. So you all can file back with the Supreme Court and just let me know
Okay.
when they issue the remitted order. Thank you very much.
Thank you.
Thank you, Judge.
You've been watching breaking news from the Las Vegas Review-Journal, sponsored by Michael Gaughan's South Point Hotel, Casino, and Spa.